Today, we are joined by the famous Princess Bauffremont, who in 1875 did something that shook the legal process. I heard that you changed your nationality in order to get a divorce. Could you tell us more about how that happened?
I was originally a Belgian noblewoman. After marrying Prince Bauffremont in the 1860s, I became a French citizen. However, our marriage was not happy. In 1874, the Paris Court of Appeal declared that we were legally separated. The separation gave me the freedom to live elsewhere. During our separation, I fell deeply in love with Prince Bibesco of Romania and wanted to marry him. However, at that time, French law did not allow divorce. So I travelled alone to Germany and obtained German citizenship in 1875.
French law didn't allow divorce until 1884, and under German law, Catholic separation was treated as a divorce. So, did you change your nationality to divorce?
Exactly. A few months after acquiring German citizenship, I filed for divorce in a German court and successfully obtained a divorce ruling. That same year, I married Prince Bibesco in Berlin. However, Prince Bauffremont, still a French citizen, remained my legal spouse according to French law. When he found out that I had claimed to have remarried, he was furious and shocked.
If I were him, I'd probably feel the same way. What did he do next?
He filed a lawsuit in the Paris court, requesting the annulment of two things. One, that I acquired German nationality without his consent, and two, that my remarriage to Prince Bibesco violated French law. Unfortunately, the French Supreme Court ruled in favour of the prince and declared that my divorce and remarriage were invalid because I had circumvented French law. Therefore, my second marriage was also declared invalid.
So, how did the French court handle your acquisition of German nationality?
That was Prince Bauffremont's first request. By then, I had already acquired German citizenship, and the French court had no jurisdiction over that. They didn't address it.
Thank you, Princess. Now let's turn to legal expert and scholar Jay to discuss the impact of this famous case on the world.
The Bauffremont versus Bibesco case became the first historic case to establish the rule of evasion of law. In the case of the parties involved, evasion of law refers to actions where a person changes nationality or residence to avoid a mandatory law that should apply. For the courts, evasion of law is a legal concept designed to negate the effects of such actions, ensuring that the circumvented law is applied. For example, when the French court heard the case, Princess Bauffremont was already a German citizen, and that fact couldn't be changed. As a result, the law that should have applied was German law, which had granted the divorce. So, how did the French court dismiss the German court's decision? The French court argued that the princess had intentionally changed her nationality to achieve a divorce, thereby evading the French law that prohibited divorce. Therefore, French law should be applied instead, and her divorce and remarriage were ruled invalid. Regarding her German nationality, the French court felt it had no jurisdiction.
So, in other words, someone who changes their nationality to get a divorce would not be recognized by the law? Is it because evasion of law is considered immoral and should be punished?
Well, not quite. Sometimes the double standards in law are quite interesting. When French courts handle cases where someone tries to evade foreign mandatory laws, the rulings are quite different. For example, in 1922, the French Supreme Court ruled in the Miss Fry case, which involved a French woman who changed her nationality to avoid the Italian law that prohibited divorce. The French court accepted her evasion because French law had allowed divorce at that time, while Italian law had not. So, in this case, the court ruled that the divorce was valid under French law.
Got it. So, evasion of law is basically a principle France uses to stop people from bypassing its mandatory laws. But what about other countries? Do they have any issues with this? How do they handle it? Is this system unique to France? Or do other countries deal with this situation in a different way?
French rule of evasion of law has had a significant impact on international legislation, with several countries following suit. For example, Switzerland enacted the Swiss Civil Law Relations Act in 1891, which states that parties cannot marry abroad just to avoid Swiss domestic marriage laws. In 1982, the Yugoslav International Conflict of Laws Act stipulated that if someone attempts to avoid the applicable Yugoslav laws, then the foreign law would not be recognized. The legislative model used by these countries is known as partial denial, meaning that only the avoidance of their own mandatory laws is invalid, while avoiding foreign mandatory laws is still recognized. In comparison, some countries take a much stricter approach, totally rejecting evasion. So, whether someone's trying to dodge domestic law or foreign law, it's still considered invalid. Take Argentina, for example. Articles 1207 and 1208 of their civil code state that even if a contract is valid where it was made, if the goal is to avoid Argentine law, then it's essentially meaningless. And contracts made in Argentina just to avoid foreign law don't hold up either. Plus, Article 6 of the 1979 Convention on General Provisions of Private International Law by the Organization of American States says that if a signatory country's law is being fraudulently avoided, all other signatories will disregard it.
That sounds a bit fairer.
These countries use the concept of legal fraud, which has a negative connotation, instead of evasion of law. Based on the legal saying, fraud makes everything void. They view legal evasion as an immoral act that should be penalized. This is quite different from countries like France and Belgium, which follow the partial denial model, where the theoretical foundation is different.
Do common law countries like the US and the UK also prohibit evasion?
Quite the opposite. The US and the UK actually scoff at the idea of evasion of law. For example, in 1958, two lovers in New Jersey were eager to get married. But according to the law at the time, they were below the legal age. So, they decided to go to Indiana, where the legal marriage age was lower, and got married there. They returned to New Jersey to live together afterward. Several years later, the husband was convicted of theft and sent to prison. The wife filed a lawsuit in New Jersey, asking the court to declare their marriage invalid. The state court followed the traditional conflict of laws method, which says that the law of the place where the marriage was registered should apply in this case. Indiana law, they ruled the marriage valid and the plaintiff lost. The plaintiff appealed to the New Jersey Supreme Court, which ruled that since the couple had lived in New Jersey both before and after the marriage, the case had no connection to Indiana law. The only state that had a real interest in this case was New Jersey, so New Jersey law should apply. Since they hadn't met the legal age to marry when they got married under New Jersey law, their marriage was declared invalid.
Wow, those two lovers sound pretty clever. How did they come up with that idea?
Yes, the couple's act of registering their marriage while constituting evasion of law was never mentioned by the two courts in New Jersey. Not only that, but the trial court actually thought that the law they circumvented, Indiana law, should apply, although the appellate court used New Jersey law, which the couple had avoided. The reason was simply because New Jersey had a stronger connection to the case.
Ha ha ha. Interesting. So why don't U.S. courts apply the rule of evasion of law?
The reason is that the U.S. sees evasion of law as a lawful act. Whether it's avoiding domestic or foreign mandatory rules, it's still considered valid. The U.K. feels the same way. Here's why. First, the legal theory in Anglo-American countries holds that since the law allows parties to choose which law to apply, if they create conditions or change the facts to make the conflict of laws point to the law they want, it's not something they should be blamed for. It's up to lawmakers to improve conflict of laws and substantive laws to reduce the occurrence of evasion. For example, in 19th century England, marriage laws required young people to get parental consent before marrying. As a result, many English people chose to marry outside the country to avoid applying English law. Later on, the UK lowered the marriage age requirement that depended on parental consent, making it almost impossible to apply, obviously. Lawmakers recognized that the best way to deal with evasion was to amend the laws and close the loopholes. Secondly, Anglo-American countries uphold the principles of personal freedom and party autonomy in private law. For example, changing the place of marriage registration to marry earlier, choosing a law with a lower marriage age, or changing nationality to get a divorce. These are all seen as personal choices and freedoms by the law, as long as they don't violate local public order or social interests.
So what's your personal stance on evasion of law? Do you support it or oppose it?
Justice Holmes of the U.S. Supreme Court once commented on evasion saying, "We should not concern ourselves with the issue of evasion, because the law only defines the boundaries of right and wrong, legal and illegal. If a person's actions are within the law, then everything they do within the rights granted by the law is beyond reproach." For me, I believe that the rule of evasion goes against the development of modern human rights concepts. Changes in residence, nationality, or the location where actions are carried out, whether deliberate or unintentional, actually reflect fundamental freedoms: freedom of movement, freedom of residence, and freedom of action. These freedoms have increasingly become a consensus in international human rights law and are actively recognized and protected by international conventions and treaties, including the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. If we accept the legitimacy of prohibiting evasion, it becomes difficult to explain why a person's exercise of constitutional freedoms should be restricted by marriage law or conflict of laws.
That's true. So, is the rule of evasion still applicable in today's society? I mean, if I want to marry an Indian wife, I wouldn't want her gaining U.S. citizenship to be seen as a way of dodging local Muslim laws.
Since the principle of personal freedom has become a widely accepted consensus in the field of private international law, the legal evasion system hardly has a place in modern legal practice. Legal evasion was first codified in France, originating during a time when the country's conflict of laws rules were chaotic and unorganized. Even up until the 1970s, French conflict of law systems struggled with rigidity and oversimplification. To address the growing number of legal loopholes in determining applicable laws, the French Supreme Court had already started limiting the scope of the legal evasion doctrine. In terms of legislation, I conducted a global search across 126 private international law codes using the keywords legal evasion and fraud in the application of law. Out of these, only 17 laws, less than 14%, contain provisions or similar rules prohibiting legal evasion. Among them, only 7 were enacted after the year 2000 in a 2007 judicial enforcement order. The French Supreme Court ruled that French courts must not review the application of foreign law by foreign courts, putting an end to the long-standing controversy and embarrassment surrounding judicial scrutiny of international marriages in France.
Exactly. The principle of individual autonomy is widely embraced and increasingly dominant in international civil relations. Hopefully, no matter where we change our nationality, residence, or place of action, our choices will be recognized by the laws of different countries.